Hello. Thank you very much for joining our webinar today. This is our webinar about our consumer protection review, and it's an opportunity for you to have your say and learn a little bit more about what we're doing in the review. Now, I'll do some introductions in a moment, but many of you will probably be very familiar with how these seminars work, but just in case not, I'll just go through a few details. We really want this webinar to be as interactive as possible, and so thank you very much to those who've already put through some questions. We've received some questions and we've tried to build them into what we're going to talk about today, but there's also an opportunity for you to feed in questions and comments as we go through the webinar today. So you can submit live questions by clicking on the question link below this video. You can include your name if you like with those questions, but you've also got the option of submitting questions and comments anonymously if that's what you would prefer. And we'll do our best to pick up points as we go through and leave time at the end to pick up any points that have come through in comments. And there's also an email address for you to send through your comments, possibly after the webinar, if you don't want to ask a live question. And again, that's a link is shown in the picture below the video here. We're also making sure that this stream will be available on catch up. And so will the slides that we speak to today, and we'll include links to relevant web pages and resources for this event. So please do feel free to share the link to this webinar and any of those resources with colleagues. We look forward to hearing from you. So I'm just going to do a few introductions right at the beginning. I am Aileen Armstrong. I'm an Executive Director at the SRA, and I'm joined today, and they'll be speaking a bit later on, by Chris Hanford, who's our Director of Regulatory Policy, and Paul Hastings, who's our Director of Client Protection. So before we really get into the conversation, I just wanted to say a little bit about the background to this review. So I think we've got some slides that we're going to pop up. There you go. I just wanted to explain that obviously we've launched a review of our overall approach to protecting consumers. And it's really about when consumers have placed their trust in a regulated law firm, we've got the opportunity now to do a review of the consumer protection there. So today we're going to talk through why we're doing the review, what we will be doing in the review, the timelines, and how we're going to be able to hear from you and many others as well. So I suppose the first question is why now? I would say that really, I think over the last 10 years or so, we think our approach to protecting consumers has been working well generally. We do think people should feel confident and that they can trust that their solicitor will be competent, that their solicitor has gone through rigorous qualification process in order to be a solicitor, and they should be able to trust that new firms too have gone through the appropriate checks. However, it is the case that unfortunately sometimes things can go wrong, and it's important that the right protections are in place when something is not working well. And so we do need to keep our own arrangements under review. And in recent years, we have been seeing some changes in the sector itself. Last October, for example, we conducted our biggest ever intervention into a law firm, and that was when we stepped in to close down Axiom Inns, where more than £60 million of clients' money had gone missing due there to suspected dishonesty. And more generally, over recent years, we've seen a large increase in both the number and the size of those types of interventions. Last year, for example, we carried out more than twice as many interventions than we did the year before. So we are seeing changes in the market. These might translate into shifting risks in the sector. And therefore, responding to that, we feel now is the right time to conduct a review. So we earlier this month we set out our aims for the review, and so I wanted to pick out those key elements. We've published a discussion paper, and that's available on our website. And again, there's a link to this paper below the video for those of you who haven't had a chance to see that or look at that yet. But on the slide that's showing now, we've really picked out, the key points. And what this is about is that over the long term, we really need to and want to ensure, first of all, that consumers are appropriately protected when using a regulated firm. And it's also important that public confidence and trust in the legal sector is maintained. And of course, it's vitally important too that there's a competitive, dynamic legal market. And that's important because it supports access to justice through enabling consumer choice while keeping the costs of legal services down. So we do want to cover all three aspects in terms of thinking through what may be any changes that we develop through this review. And just in terms of how we're conducting the review, it's really important. It's been important to us, and I wanted to kind of just explain that, we think it's really important that we look at things through a really wide lens, and that is in terms of the types of issues that we want to look at, and any issues that we haven't already identified is one of the things that we're really interested in hearing from people about. And perhaps there will be comments on, other things that we can cover. But it's also a really wide lens in terms of making sure that we're seeking and hearing as many different views as possible. So this webinar is one opportunity for that, but there will be plenty of other opportunities as well. So then we're going to come on and talk with Chris and Paul about the scope of the review. So just to highlight really the two main areas that we're going to be looking at here. We're going to look at our own policy and operational arrangements for really identifying, when there might be risks to consumers. So that's the first element here. And then the second element that I want to kind of highlight is that we're also going to be looking at, in those in unfortunate places where something has gone wrong, we have the compensation fund, and we want to review that compensation fund model in light of the risks that we understand from this review. So I'm going to move us on into some of the detail and come to Chris here. I really going to invite Chris just to talk about that first limb about our own policy and operational arrangements. And Chris, could you just take us through a bit of the detail of how we're going to approach this?
Yeah, sure. Thank you, Eileen. So the first main strand of the review is to consider whether we can reduce the risk that consumers suffer harm in the first place. So that will mean looking at how we identify risks in the sector, how we monitor and approve firms, as well as our rules and controls around firms holding client money. There are sort of several ideas and options that we are keen to explore, and they're outlined in the paper that Aileen's mentioned. So I should flag again that we want to explore a broad range of issues and questions, and even those that are a little bit sort of further away from where we are now, and might be sort of potentially significant changes and arguments, potential arguments for and against them. So there are 7 of the ideas set out in the paper, and just to give you a flavour of some of those and the sorts of ideas, we're looking at things like strengthening checks and controls as part of our authorisation approval process. So should we be looking more at kind of business plans, funding plans, governance structures? Are there other organisations that we could check in with more closely, like the HM Revenue and Customs, for example? Questions around firms holding client money, and whether there should be restrictions on firms holding client money. So we could, for example, explore with other regulators, escrow account providers and insurers, different approaches to managing the risks around holding client money. So that could include alternative options to hiding client money or certain categories of client money. We can consider whether there are certain circumstances when it is or isn't prudent for firms to hold client money at all. So we could also think about new targeted controls around client accounts and money. So are there certain risk flags that means we should have tighter restrictions, more controls on certain firms, or certain business models? So for instance, linked to the type of the work the firm does or the client profile. We could review the ways in which money is taken up front in advance of work being done, or our rules around managing residual balances. All firms that hold client money have to get an annual report from an accountant. We could review our requirements around this and how they work in practice. We could think about assessing ownership and ownership models and corporate structures a bit more. So looking at different ownership models, corporate structures, and whether some carry more inherent risk than others. So that's the sort of things that we'll be looking at, to give you some examples.
That's really helpful. Thank you, Chris. I'm going to come to Paul next. Obviously, the compensation fund is the second large part of this review. So, Paul, I wonder if you could just take us through how we'll be looking at this during the review, and really about how we're going to make sure that there's appropriate consumer protection in the long term. Paul.
Yes, thank you. Yeah, as you've mentioned, this is the second main focus area of the review. The compensation fund provides a safety net for consumers and plays a vital role in both protecting consumers and helping to maintain trust and confidence in the profession. So just to provide a bit of background on the fund for those who might not be familiar with how it works, the fund is made up of annual contributions by everyone we regulate. Payments from the fund are then determined by a set of rules that were implemented in 2021. That was after a substantial consultation process on those new rules. The current maximum payment for a single claim is £2 million, and we can make payments where money has been stolen or not been accounted for by someone we regulate, or where a regulated person did not have insurance in place.
So we did have actually a pre-submitted question from Andrew, which relates to how the current arrangements work. And so I was just going to ask Paul to address that. The question that was submitted was, why have the compensation scheme paid out in the Axiom Inst case, given that it's a fund of last resort, and where the partners of that firm and Plexus who received money must surely have had the missing money? Should they not be the first place to look and to seek to recover? Paul.
Okay, yeah, I'm happy to try and explain the position with regard to Axiom Inst. We consider that the scale of consumer loss, if the cap had been applied, would have been too large and would have led to an unacceptable loss in public confidence in solicitors. To put it in context, to date, we've received claims totaling approximately 33 million. And if we had applied the cap, hundreds of consumers would be receiving only a relatively small proportion of their misappropriated funds. We're also aware that there's a claim against Axiom Inc.'s professional indemnity insurances, which is underway, and the level of funds which may need to be recovered for an existing freezing order on assets is still to be confirmed. If funds are recovered from the insurance fund or from the sale of frozen assets, then these would be used to replenish the compensation fund. But in the interim, it is important that we support consumers through payments through the compensation fund, rather than the alternative of forcing them to wait until the conclusion of the insurance claims. So that's briefly why we've decided not to apply the cap in those circumstances. I'll perhaps use that as a point to go on and kind of relate back to the further review and what we're looking to do. As has already been mentioned, the fund has been under increased pressure in terms of claims. So through the review, we'll be exploring how we get a balance right between providing appropriate protection for consumers and any impact on the cost of legal services. As we've already mentioned, the fund has stood up well historically, and we know that many people in the sector recognise the value it provides and the importance of making sure consumers are protected. We therefore expect to hear strong arguments for maintaining the current level of protections, but we need to be sure that the fund is sustainable and proportionate in the face of evidence of escalating risk. The review will enable us to consider a number of options. For example, how we tackle the risks around fraud and dishonesty may need a different solution to how we manage the risks of firms failing due to other issues or behaviours that could still lead to putting money at risk, client money at risk. The paper sets out a number of options we want to explore, and these are wide-ranging, but includes ideas such as revising the capping provision. Our rules do allow us to impose a discretionary 5 million cap, but that is a fixed cap on claims. As we mentioned, we did not use this cap in the case of Axiom Inc., as the scale of consumer loss would have been too large and led to an unacceptable loss in public confidence in solicitors. But we could change the rules around the cap to give ourselves more flexibility. For example, we could introduce aggregate limits for claims per person, per firm, per instance, or connected instance. Alternatively, some regulators set a maximum total fund that will pay out each and every year. We could also look at reducing the maximum payment amount for a single claim. As I've already mentioned, this is currently £2 million, but we could reduce that further. But it's important that we realise that the average payment outs for the fund currently are less than 40,000. So we need to consider what practical implication that would actually have on the fund's viability. We could also further limit who can make claims on the fund or what transactions are covered. There could be greater targeting of the fund towards cases of hardship. We could look at limiting the type of transactions that are covered. Or finally, we could consider insurance options that may be available. We could explore whether consumer redress could be provided by insurance arrangements. Firms can choose to insure against fraud, dishonesty by their staff or other directors. That insurance can only cover those who are not involved in the fraud. Obviously, you cannot insure against your own dishonesty. However, some regulators have put in place their own insurance-based compensation arrangements instead of running a compensation fund. So that's a very different option that we could consider.
Thank you, Paul. Look, there's clearly a lot of issues here to consider, but I think I know that some people may be concerned that in launching a big comprehensive review, that might mean that we just won't act for months, perhaps. If we have to look at all of these issues. But we have tried to be clear in what we've put out already, and I just wanted to reiterate now that we will act sooner where it's sensible to do so. So just turning to Chris again, I wonder if, Chris, you could say something about the steps that we've actually already taken.
Yeah, of course. Yeah, so it was important to act quickly and we could make changes that would benefit the public, and we have taken action. And we'll continue to make changes throughout the review where it's practical to do so. Obviously, others, as I mentioned earlier, will take time and need extensive engagement and consultation. So following the Axiom Inc. intervention, we have started a review into our internal processes. And so, for example, in the Axiom case, it was our visit to the firm that ultimately identified the suspected fraud. It was kind of missed bugs along the way. So we've been questioning whether there's anything else that could have helped us pick this up sooner. So, for example, we've increased our checks around bank statements to reduce the risk of concerning activity not being identified. We've also strengthened our monitoring of areas where there may be increased risks. So we're progressing a programme of inspections of what we call accumulator firms, so firms that have grown through acquisition, to assure ourselves that any risks to the public are being appropriately managed. We'll also be visiting other firms who have grown rapidly, and then we'll share with the profession evidence of good and poor practice. And we're building into our prioritisation criteria for targeting future monitoring and oversight activity, the risk factors that are being uncovered and identified through the Axiom Inc case, as well as those from visits to the firms, as I've just mentioned. And then just finally to mention that our oversight regulator, the Legal Services Board, is also carrying out an independent review of the regulatory events leading up to the intervention of Axiom Inc, and we're liaising with them on this, and we'll take into account their findings and any additional lessons that have been learned.
Thanks, Chris. So I'm also going to come on to the timeline for the review in a moment, but just to remind anyone who's listening in that you do have the opportunity to add your comments, or please do ask any questions in the live questions on screen. So please put through anything, and we will do our best to pick them up as we go. But just coming back to the way that we're going to progress the review, and coming back to Chris, could you please just set out for us the timeline that we're currently foreseeing?
Yeah, sure. So, I mean, there's quite this extensive period of engagement that is underway, and as I said, we'll start to implement changes that can be sort of the quick wins as we go. Our thematic review is underway at the moment, or is about to start, and we will develop kind of policy as we go, as well as we are talking to people and learning from that. But as I mentioned, where there are these kind of more potentially far-reaching and more fundamental changes, and they'll take longer to implement. So if we need to change our rules, then it will need extensive engagement and robust impact assessments, formal consultation, approval by the Legal Services Board, and then a period of transition and of implementation. So the timetable for that is written on the slide there, and the sorts of things that might be included are changes to our sort of fundamental changes to our accounts rules and the circumstances when firms can hold client money, if at all, changes to our rules around the criteria for approving firms and role holders such as compliance officers, introducing any new ongoing controls in firms' structures or reporting, and then sort of changes to how we run our compensation fund, as Paul has set out. So yeah, as I said, on the potential timeline on the slide there, so beyond the engagement period goes up until the summer. We anticipate a number of steps. So thematic review, and then listening to our stakeholders, we'll develop policy and begin implementing changes that we can change. Towards late 2024, we'd launch a public consultation, and then going into 2025, we'd review the consultation findings and decisions, submit an application to the LSB, and then work towards implementation of any changes.
Right, thanks again for that, Chris. Now, obviously, this is a review of how we protect consumers. So again, I was just going to invite Chris to say something more about, obviously it is really important that we, through this review, hear from consumers, and really about how we're going to make sure that their views stay kind of central to this review, and ultimately, you know, how we can use this review and the thinking through it to really help maintain trust and confidence in legal services. Chris, just a few reflections on that, please.
Yeah, thank you. So yeah, we'll be having lots of conversations with different groups, and we'll be going out to them directly. And this will include consumers and legal services, and also their representative groups. I think you're going to touch on some of the events that we've already got planned and how people can get involved later. But ultimately, we want to make sure that we engage with the full range of stakeholders that are interested in this review or impacted by it, and that really does include consumers. And throughout with this review, we'll be asking ourselves the question about how we can make sure the public maintains trust and confidence. And obviously, aside from this review itself, that's our priority, and our current mission statement is driving confidence and trust in legal services.
Yeah, thank you. And I mean, I think it's a real fundamental of how we're going to conduct this review. So thank you very much. So speaking to everyone else now, really, you've heard about why we're doing this review and what we're hoping to achieve. To get there, however, we really do need views and input from you and you know, many stakeholders. So we really want to make sure that we're gaining as much input and insight from others as possible. Just to be clear, we are not at the point of setting policy here and now. We're really keen to hear your observations, your ideas, any evidence you have of what works, and that might be from other sectors or other jurisdictions. We really do want to create that opportunity for input. And you know, actually, we've been really pleased. I've got a question that's just come in now, and we've also had a good range of questions and comments that were pre-submitted before we started this webinar today. And I really just want to encourage you all to keep feeding in views. So I just want to play back some of the questions and comments that we've heard already. So there's a question that's come in just now, which is about, let me just get it on my screen. You know, are you, the SRA, going to consider whether firm accounts should be reviewed by independent auditors rather than accountants that are employed by the firm? That question, I don't think had a name against it, but we've had there's a question here as well, or a comment come through from Andrew, who said the Bar Standards Board regulated lawyers already use third-party managed accounts instead of client accounts for all of their payments, and that they're not allowed to use client accounts. So the question he's posing is, you know, how serious is the SRA about the possibility of moving to a similar or the same working model, you know, which he says has proven to work for BSB regulated lawyers. We've had another comment, and again, the range of these is great. This one from David saying, does the SRA consider it necessary to introduce closer scrutiny of mergers and acquisitions carried out by regulated firms? And asking, you know, what should firms be doing now to prepare for in terms of a future SRA approach? And there's also been a comment from Rachel, who said, has the panel thought of keeping private email addresses for all partners or directors of firms, and each year asking a series of questions about whether the person has any concerns about the health of their firm, and this could, she says, potentially create an alert, you know, for the need for early help. You know, I think there's a whole range of issues coming in, and certainly, you know, I think we can be looking at the rules around audit by accountants and how those rules work. And just an observation, you know, that actually what we want to do here is that range of issues that have been raised. We might not have, or we're certainly not even intending to have the answers up front, but through the review, we want to explore all of those issues that have been raised. And as I said at the beginning, potentially others that we haven't thought about. So these are all considerations that we'll certainly be looking at through the review. I did also want to pick up a question of a slightly different nature that came in. This one is from Adrienne, that I was going to ask Paul if he's okay to comment on now, actually, because rather than quite the subject of the review, I think it's some of the context and the situation that we're dealing with. And so Adrienne had posed the question of, you know, what the likelihood is of firms being asked to contribute more to the compensation fund in the coming years to make up for the shortfall caused by the Axiom intervention. So Paul, I wonder if you could give us a few comments on that, please.
Yes, I'm happy to try and answer that question. So yeah, in our November statement, we said that we would not be calling on solicitors to make an in-year contribution. At that point, we would keep it under review in the light of any further interventions or unforeseen events. And that remains our position in regard to any interim payments this year. We've yet to make a final decision in relation to the 24-25 contribution, but given the impact of Axiom and the increase in volume of interventions, it is likely that we need to increase the contributions. But I think it's important that we recognise that this is against the background of a gradual reduction in the fee over the last 4 years. I suppose longer term, this review will be critical in helping us understand the level of contributions needed to ensure the viability of the funds going forward. So that's one of the key purposes of this review, to help us understand what level of contributions we will be needing in the longer term future.
Thank you, Paul. That's really helpful. So another question that I've picked up from the webinar today, or a comment kind of saying that law firms have been able to use third-party managed accounts since 2018, and the question here being, you know, why do we think so few have chosen that option, chosen to use that option? And I think again, a really helpful contribution for our review. Thank you. I think it's important, again, I don't think we have all the answers to that, and so as part of the review, in order to be able to get to the bottom of some of these issues, to be able to identify if there are different options going forward, is that we certainly should be and will be engaging with the providers to really understand kind of what level of take-up there has been, and where it hasn't taken off, you know, maybe to get behind the reasons for that. And I'm also conscious, I think we've also really helpfully, thank you, got a number of comments come through where people are already giving their views, which we really welcome, about the merits or you know, the pros and cons of different things that I think we've flagged for the review, different ideas. Please keep those coming. I think rather than attempt to have that debate in this webinar. I think what we're going to do is we really encourage those different views. Please let us know kind of where you're coming from, and also if you have evidence or ideas of areas that we should look at in more detail where there might be more evidence. You know, we would really welcome that kind of input as well. And also another question that has just come through is to kind of check, for us to check that we're considering what side effect changes, I guess kind of collateral changes, and what collateral impact there might be of any changes we suggest through this review on other areas. And I think the example that's been given here is, for example, the ability to do AML checks, or you know, the ease of accessing services for clients. And again, I think that's a really helpful input and reminder and check for us, that, you know, in doing this comprehensive review, I think we have already spoken about the review having lots of layers, and there's going to be needing to find balances in terms of the options that we potentially propose going forward. And I think another key message illustrated in that comment is that we do need to look at this in relation to impacts on anything else we do and the wider sector generally. So we're really grateful for those comments. As I say, please keep them coming. I'm actually going to move us on. I think I'll just check whether there was anything further. So a further question about whether the just reading it out, the SRA is tied to maintaining superior protections for clients by comparison to non-regulated providers. So Paul, I wonder if you would want to comment on that one.
Yeah, happy to. So, I mean, I suppose that is one of the things we're looking at. Going back, I mentioned earlier when we introduced the new rules in 2021, we did do a lot of comparison there to have a look at what other providers were providing, other regulators, and level of provision they did. I think we recognised that what we provides a good level of protection for clients, which we felt at the time was important. Again, the feedback from people in this review will be us to understand actually, have we got that balance right between the level of protection and the potential cost to the legal sector. So that's a fundamental thing. I don't think we're committed either way. It's about us understanding what the market demands at the moment.
Thanks, Paul. Yes, I mean, definitely feeding that one in too. Thank you. So I was going to just talk about a few next steps. Look, you know, it's been hugely useful to hear from you already today. As I said, some of the debate we will be able to look at in slightly slower time, and we will certainly pick up all of the points that have been made today. But as I said at the beginning, today really is a sort of kickoff. It is there is a lot more engagement that we're planning between now and the summer, and I just wanted to flag that includes a series of roundtables throughout March. So just to call out some dates for those events. On the 12th of March, we have a roundtable with representatives from high street solicitors focusing on issues concerning probate and conveyancing. The next day, on the 13th of March, we will have a roundtable with representatives from consumer groups. And then on the 21st of March, we've got a roundtable with solicitor representation groups. And on the 26th of March, we're also planning a roundtable with representatives of local law societies. And beyond those that are already kind of highlighted, we're going to be holding a number of focus groups and having discussions with other regulators and members of the profession. And if you're interested in attending any one of the roundtables that I've mentioned, or have initial views that you haven't had the chance to share with us today, then please do get in touch. Please email us. As I said, the email address I think is under the video here, but the email address is the Consumer Protection Review at sra.org.uk. So I think that brings it to me to really bring today to a close. I want to thank Paul and Chris very much for joining me. I do hope that we've been able to, with a bit of a whistle-stop tour, kind of bring to life, what we had put in the document that I referred to right at the beginning, but it is there on the website for you to have a look at if you want to look in more detail. And so we'll certainly take away all of the issues that we've heard today, and what we'll try and do is try and build any points that we haven't picked up today into future communications, so that you can see what we're doing with those. And I think, just to thank you all for your participation, and I hope you have found it useful. We would really welcome your feedback on this event as well as all your input to the review. We'd really welcome your feedback on this session. So please do let us know what you thought of this session, and you can do that by clicking on the feedback link below. And it does only take a minute, and we do look at it all, and it will help us improve what we do going forward. And yes, just a reminder then to put through any comments, any ideas, any thoughts on the wider review on that email address. And until we pick up any of these points again and have any overlap, thank you very, very much for your time this afternoon. I hope you have a good rest of the afternoon. Take care. Thank you.